Have you created some special sauce type of software or product that you're looking to license out to third parties in order to increase the earnings of your business, an amazing business idea? Well, then this video is for you, because in this video, we're going to talk about the different kinds of licenses that we generally see in the Canadian market, providing some overview and description of each of these kind of licenses and why somebody might want to partake in that form of licensing. If you're new to the channel, welcome. My name is Pamela Metani. I'm a business lawyer and the founder here at Graphene Business Law, a law firm working exclusively with business owners and entrepreneurs and doing so virtually throughout the province of Ontario, Canada. If you're new to this channel, don't forget to give this video a big thumbs up and click on the subscribe button down below. We post free educational content multiple times a week here on YouTube, solely for your benefit as business owners and entrepreneurs. Not to mention, no one else is doing it. So please give us that like and subscribe as a reward for all of our hard work and the time that goes into the making of these videos. Without further ado, let's talk about licensing. First of all, before we get into the different kinds of licensing, what does licensing mean? Licensing a product, in simple, big picture terms, is granting permissions to someone else to use your special sauce. Licensing can vary among industries. There are different matters you can license. For example, somebody can license something that is completely intangible, like a software product, software package. Somebody can license a physical good or product. When talking about licensing, we are usually, in terms of that granting of the right to use the special sauce, we're usually talking about it in lease terms. So the licensor, the person that created or owns that special sauce, still retains ownership of it, and you're getting sort of a pass to use it for however long is discussed in your agreement. And yes, licensing should always be followed, the conversation of licensing should always include an official agreement to make sure that no party is taken advantage of. Some of the most successful, most billion-dollar deals out there in the business world today are as a result of licensing certain products. So it would be an understatement to highlight how lucrative the licensing of a certain legally protected piece of intellectual property can be. So we mentioned at the beginning, big picture in the Canadian market, and I know we have a lot of viewers from the US as well. I suspect there'd be a lot of overlap in your markets as well, so this video would be some value add to you watching as well. But big picture in the Canadian market, we're talking about three kinds of licensing: non-exclusive licenses, sole licenses, and exclusive licenses. Some of them are what they sound like. For example, non-exclusive and sole and exclusive can be a little confusing, but we'll go over them in this video. When we're talking about a non-exclusive license, that is you as the licensee leasing or temporarily holding the rights to do something with that legally protected intellectual property of the licensor, for example, a certain period of time, or for example, in a certain geography, usually referred to as territory in licensing agreements. It's important to note that in holding a non-exclusive license, the licensor, the creator, if you will, of the special IP sauce you are renting out, the licensor has the right to further license their IP to other individuals. When I say IP, again, it could be a product, it could be a software, but there's some intellectual property there that you are licensing. This may or may not be beneficial to you, depending on your business acumen, depending on your confidence levels, depending on the industry itself, and a host of other factors. In being non-exclusive, it means that, for example, if you are licensing something in the province of Ontario, there could be another party licensing that very same product from the licensor in the province of Quebec, and those are your territories. You might even be licensing within a small geographical area within a certain state or province and not even the whole state itself. Or sometimes you might be licensing in a country altogether. So you're responsible for Canada rights, someone is responsible for US rights. But whatever the case may be, in non-exclusive licensing agreements, the licensor has the right to have the same deal and rent out their intellectually protected product or service to another party, such as yourself. Important to note for your protection is that these licenses often have a most favored clause, meaning that if the licensor is going to lease the same product to another party on more favorable terms than your lease, if you will, they should offer you those more favorable terms as well, no matter what point in the agreement you're at. The other type of license we mentioned is a sole license. While it's not seen nearly as commonly as other kind of licenses, I find that the term of it can be confusing because it might sound synonymous with an exclusive license in the sense that sole means one, and if you're exclusively doing something, you'd imagine you're the only one of your kind doing that as well. Under a sole license, it is important to note that a licensor generally cannot grant that same license to any other third party. However, a catch here is that the licensor can themselves carry out in offering whatever intellectually protected product or service they have created themselves. So in essence, there is still competition even with a sole license because you could be competing against the licensor itself. Like I mentioned, sole licenses are not that common, but we still see them. And again, be careful not to confuse them with the concept of an exclusive license because both terms are synonymous with you as the licensee being the only one. In both of them, you are the only licensee, generally speaking. However, the behind the scenes catch is that in only one of them, you are the only player. In the sole license arena, you're not the only player because the licensor also retains their rights. With the third type of license, exclusive licensing, this is where things can become really advantageous to you as the licensee. And when I say advantageous, of course, I don't mean it's a free-for-all. You're going to pay for whatever benefit you acquire, right? If you negotiate exclusive licensing rights for yourself, it's going to come with a heftier price tag, generally speaking, for you, than if you were a non-exclusive distributor or licensor, for example. In the exclusive sense, as I mentioned, the licensor may not license the product to any other party, and really importantly, the licensor may not promote or use or sell, if you will, that intellectually protected product or service themselves either. Exclusive licenses can vary greatly in terms, so it's really important that you seek out legal advice when signing or drafting a license agreement. And of course, here at Graphene Business Law, we can help you with licensing agreements. Exclusive licensing, as well as I mentioned, usually comes with a handsome cost to the licensee, including the fees you will undertake just for setting up this, product and its avenues of distribution, just for the risk and effort you're going to take in trying your shot at this product or service and its promotion. Because when you exclusively license something and you're the only one, you'll either make it or you won't. So there is substantial risk there. And again, you're going to pay handsomely for that licensing fee as well, because you've taken the creator himself out of the game. There's a lot of benefits to the creator himself, so don't think, why would somebody just sell their baby? That's not what they're doing. They're going to make money off of you for as long as you are in that exclusive licensing game. And if you want to know more information on the details of certain types of licensing we've discussed today, whether it be non-exclusive, sole licensing, or exclusive licensing, let me know. Put a comment down below. It's one of the best, thank yous and ways of engagement you can leave with this video, and one of the best ways to show appreciation for all of this free educational content that we put out there. And of course, if you are a business owner or entrepreneur, either looking to license out one of your products, so on the licensor or the licensee side, you're welcome to contact us at our welcome email, info@graphenebusinesslaw.ca. And of course, our website is graphenebusinesslaw.ca. Otherwise, I'll end the video there. Don't forget to give it a thumbs up and subscribe before you head out. And thank you so much for watching.